Last year, at the ICON's annual conference held in Madrid, we had our first inaugural section with 3 presentations, one by a member of the network, Professor Shepard from Canada, and 2 others by guests, Professor Andrew Spalding from the United States and the Spanish judge on the European Court of Human Rights, Professor Maria Elosegui. The videos of all of them are available at the IGER website. Since then, it should be noted that Professor Shepard and Ramirez Cleves has offered to collaborate as commoners of the IGER, and I will, thank you. Well, I said since then, it should be noted that Professor Shepard and Ramirez Cleves had offered to collaborate as conveners of the IGER. And I would like to take this opportunity to thank them for the gesture and welcome them to the task. And also to mention that Professor Gonzalo García Pino and his team of Chilean constitutionalists has also joined us. In this context, I would like to very briefly announce that we would like to propose some initiatives. Firstly, to actively update the website, incorporating references to publications of interest to the subject and ideally direct access to them. Secondly, to revitalize the IGER's information distribution list. Everything is now in place for people to register and receive instant information via email, although we are also testing dissemination through all the social networks. Fourthly, we will link the academic activities organized or promoted by members of the group to the network, so that either online or in person, the participation of other members is facilitated. Fifthly, we will promote the involvement of the IGER in the meeting at the International Constitutional Law Conference organized by the Universidad del Externado in Bogotá next year, and another at the Philosophy of Law Conference organized by the Internationale Vereinigung von Rechts und Sozialphilosophie in Turkey, also in 2026. Finally, we will try to promote a 4th meeting at the next year's ICON's annual conference. Finally, we will begin to develop a publishing activity that will serve to disseminate the result of the activities promoted or facilitated by the IGER. I will conclude by saying that in this session we have 4 speakers with strong links to the interest group. Thus, perhaps in order theoretically, because Magdalena Correa, she has not arrived yet, it was thought that the first one was her, who is Professor of Administrative Law at Universidad del Externado de Colombia. Second will be Juan Antonio Cruz Parcero from the Universidad Nacional Autónoma de México, who will speak about human rights and neoliberalism. Thirdly, André Rufino Vale from the university hosting us today will speak on mutations in the rights to information and data protections, new theoretical challenges in the emergence of computer information networks. And finally, Rubén García Higuera from the Centro for Political and Constitutional Studies in Madrid will speak on internet access as a human right, justifications, obligations, and regulation. Each speaker will have a maximum of 15 minutes. If Magdalena arrives, strictly timed. If she doesn't arrive, we have an opportunity to be more flexible. And we have almost half an hour to debate between those present and the researchers following the broadcast remotely. And of course, to speak about the ideas or projects about the evolution of the IGER, of the Interest Group on Human or Emerging Rights. So thank you very much for your attention. And firstly, Juan Antonio, you have the floor. Thank you.
Thank you very much. Thank you very much, Jose Mari Sauca, for inviting me to this group. It's my first presentation in this group. I'm going to talk about human rights and neoliberalism. Critique of the language of rights and critique of human rights in particular is not new. Since Bentham and Marx in the 19th century, some attacks were made against the idea of natural rights and the rights of men and citizens that were proclaimed with the French Revolution. In this paper, I will focus on a critique has gained relevance in recent years. I'm referring to this accusation that human rights have served neoliberalism to extend its ideological, economic, and political dominance over the last 50 years. This thesis contains claims that vary in scope and degree. There are more radical claims and others that are more measured. I summarize recent critics in 3 types of claims. First, human rights movement contributes with neoliberalism to underpin a moral conception that serves the market system. Second, the human rights movement was a weak companion to neoliberalism, unable to address the causes of human rights violations. Third, human rights became a demand to satisfy minimums, and equality was forgotten. I will call the first and the more radical claim the thesis of complicity of human rights with neoliberalism. The second I will call the thesis of accompaniment, and the third is a thesis about the widespread of hegemonic use of a sufficiency threshold concept of human rights that forgot equality. Another novel aspect of these critiques is that some of them have emerged from an intellectual history of human rights or a new historiography around human rights. Reviews such as Samuel Mons have the virtue to throwing up questions that challenge academic and political common sense, which today seems obvious and necessary. Some of the debates that have emerged have important implications for philosophy, ethics, philosophy of law, and constitutional law. This is why I believe it is important to look closely into these debates. Rights and neoliberalism. Mons sustains that thesis of human rights Mons sustains that cases that human rights ended up in the last decade of the 20th century as a silent companion of liberalist policies. With this thesis, he confronts the vision of authors such as Naomi Klein, Susan Marx, who speaks of a certain complicity of human rights with neoliberal policies. The later thesis, which is more radical, has been made strong by Jessica White's recent study. White tried to show that the prevailing idea of the concept of human rights was imposed by neoliberal visions. These themes have been present since the foundation of Montpellier Society in 1947, because neoliberalism is more than an economic theory. It is also a moral theory based on human rights. The thesis of complicity. The idea that human rights have been fundamental parts of neoliberalism is a way of bringing Marx's old accusation, the accusation that rise of the French Revolution were bourgeois, to the present days. I focus on the thesis of the Australian scholar Jessica White, who does a very complete job of reviewing the ideas of the founders of neoliberalism. Also, authors such as Mises, Hayek, Friedman, Rothke, Whitehouse understand that the shared idea that individual rights, including certain freedoms, the idea of human dignity and property, are part of a moral conception that is required for the proper functioning of the market. The enemies of neoliberalism were, on one hand, totalitarianism, communists, and fascists, and by the other hand, the welfare policies of socialists and social democrats in European countries and United States. The system undermined individual property, freedom, and the family. For authors such as Hayek, economic, social, and cultural rights were nonsense, and no declaration could guarantee a certain level of welfare. Society has no duty of care of its member. Society is simply a spontaneous order that arises when individuals and families pursue their welfare in the market. Neoliberalism rejected universal provision, rejected benefits in terms of entitlements, and rejected redistribution to achieve greater equality. However, they accept that providing a subsistence minimum by the state was compatible with the market. Neoliberalism actively supported the coup against Salvador Allende in Chile, which brought Pinochet to power together with the Chicago Boys. Friedrich Hayek and the American Milton Friedman were advisors to Pinochet. Much has been discussed about the significance of this complicity of the neoliberals, but now the accusation extends to human rights movement that began to flourish at the same time. White refutes Moin's assertions that the accusation of complicity by Amnesty International, Human Rights Watch, and other NGOs was an exaggeration. White stresses that the neoliberals somehow appropriated the idea of human rights as their policies, including the coup itself, were necessary to ensure freedom, human dignity, and human rights themselves. White tells us that it was in Chile where the neoliberal discourse of human rights was consolidated. The vision implies that economic freedom and the competitive market ensures human rights. In this sense, human rights NGOs with an explicit apolitical agenda, one that tried to avoid political conflict or its denunciations, could end up serving neoliberal policies. Human rights were thus complicit with neoliberalism because they morally underpin and it underpinned it, and because the human rights movement ended up adopting the conception of human rights that neoliberals made prevail. The thesis of accompaniment. Moin's thesis aims to moderate the judgment on the relation between human rights and neoliberalism. In his analysis, he not only rejects extreme judgments, but attempts to show that history of human rights did not obey a linear teleological history, but a series of competing ideas, a history of discontinuities and ruptures. For Moin, allegations like Klein or White's are exaggerated and implausible. They do not properly position human rights in their neoliberal age. Most of the process of implementation of neoliberalism did not occur in dictatorships, but during the democratizing processes in both Latin America and Eastern Europe. Human rights surely did not bring the neoliberal age about. One of the Moin's arguments against the complicity thesis is to understand that the role of economic and social rights play in the idea of human rights after the World War II. These rights were reinterpreted as international tools of status equalization and supranational accountability. They did so at the high price of material fairness at every scale, which human rights was lacked the norms of human rights movement the will to advocate. Human rights did nothing to interfere with the idea that there was not a need to set a ceiling on distribution equality. Devoid of the national welfare environment, human rights emerged in the neoliberal era as a weak tool to address only the problem of sufficient provision. For Moy, one of the dominant conceptions of human rights related them to the basic needs. The concept of basic needs emerged from the notion of development and internationalization of the welfare state. For the first time, people began to think that it was possible for individuals to achieve the satisfaction of their basic needs at the global level. The rise of basic needs paradigm and its linkage to human rights explicitly reveals how the vision of sufficiency distribution replaced an earlier notion of material equality. For Moy, this nexus between basic needs and human rights was crucial to the development of human rights in the neoliberal period. The growing interest among international organizations such as the World Bank and the United Nations to address global poverty resulted from distributional failures of national development policies. As the wealthy elite in developing countries were stronger, so did poverty and inequality. Poverty alleviation, Moy tells us, suddenly emerged as a prime imperative precisely on the wings of false expectations. Authors such as Peter Singer, Amartya Sen, Henry Shue, and among others, play an important role in the linking basic needs with human rights. While the concept of minimum threshold was not entirely novel, the notion of basic needs served several functional purposes. For instance, the notion that social rights could be enforceable gained significant traction during the last decade of the 20th century and the first decade of the 21st century. Some final considerations. We have reviewed two theses that affirm the relationship between human rights and neoliberalism, and the accusation that this relationship forgot about equality. The thesis of complicity shares a close conceptual link with neoliberalism. As Wyatt argues, neoliberalism did not merely appropriate the idea of human rights, it is incorporated as a core element of its ideology. However, the argument falls short by assuming that neoliberalism's conception of human rights was the only one in circulation. This view overlooks the diversity of interpretations and the fact that neoliberalism understandings did not dominate across all contexts. As a result, the argument fails to demonstrate the broader scope and the influence of human rights beyond its resonance within neoliberal cycles. In contrast, the sufficiency thesis advanced by Moy does not share the close conceptual relationship with neoliberalism. As discussed, neoliberalism tended to reduce human rights to property rights and select civil and political liberties, explicitly rejecting economic, social, and cultural rights, even in their minimal expression as basic needs. Yet, as we have seen, the conception of human rights as basic needs remained highly influential, particularly between international organizations, certain NGOs, and academic circles. The problem I see with Moy's silent accompaniment thesis lies in the portrayal of the human rights movement as moralistic, dreamy, and fundamentally apolitical. However, this conclusion is not supported by the historical record, which reveals a series of ruptures, reinterpretations, and diverse actors that have shaped the recent trajectory of human rights. It's necessary to review Moy's specific points regarding how much authors as Sen, Shue, Biggs, Alston conceptualize human rights. These ideas did not arise from mere philosophical or legal reflections. Rather, they emerged during a period marked by disputes over economic development and at the end of the Cold War. Understanding the economic conflicts of that time is important because human rights were interpreted differently. Given that neoliberalism became the dominant economic paradigm by the 20th century and remains so into the 21st, its version of human rights inevitably gained ground. Still, it would be incorrect to assume it was the only influential one. In Latin America, for example, human rights have been advanced through broader, more inclusive framework. While neoliberalist interpretations might have found support in institutional settings and private universities, NGOs and social movements have typically adopted more expansive and gradualist approach. Thank you so much.
Thank you, Professor Cruz. And now, yes, thank you. And now, André,
Hello, everyone. It's a pleasure to be here with you today, my beloved University of Brasilia, at this important ICONS Congress to present on this panel of the interest group on emerging rights, coordinated by the dear Professor José María Sauca from the Faculty of Law of the Carlos III University of Madrid. My objective in this panel is to present some reflections that emerged from the research I have been conducting over the last year on the new challenges that the emergence of new computer information networks imposes on fundamental rights, in particular the rights to information and data protection. The current technological revolution is creating technical conditions for the construction of information networks dominated by computers, which dispense with human interaction. That is the point, and thus pose difficult challenges for constitutional democracies, especially for the legal protection of new fundamental rights that arise from unprecedented individual and collective demands in the face of the entirely different political and social reality. History shows that technological revolutions imply the emergence of new rights, but the current revolution of information networks has no historical precedent. Artificial intelligence and the current technologies that enable machine learning pose more difficult challenges for the guarantee of new rights. So the question, how should democracies protect the new human demands against the collection, storage, security, use, and manipulation of personal information by computer networks? In the coming years, I think the well-known rights to information and data protection will be in permanent transformation. Therefore, the study of these mutations requires theoretical efforts to identify, analyze, and conceptualize. That's important for the theory. Conceptualize the emerging rights within constitutional structures. Currently, the social transformations is constantly developing this process of affirming new fundamental rights, particularly the process of specifying rights protected in legal system. We live in a changing world permeated by constant process of specifying fundamental rights. So I think that in the current digital age, social changes resulting from the implementation of new communication technologies generate new demands and claims that have repercussions on process of specifying the well-known rights to information and privacy. The last 2 decades have been marked by this process of specifying the rights to information and privacy, with the consolidation of the right to data protection in various legal systems. Today, In a world undergoing a technological revolution, the effective legal protection of personal data has become one of the fundamental foundations of constitutional states. However, that's the point. It's also important to consider that current technological transformations in communications and computer networks are becoming increasingly rapid and innovative, and they continue to constantly pressure the rights to information and data protection with new demands. In recent years, the rapid development of new artificial intelligence technologies, coupled with new developments in biotechnology, has brought unprecedented challenges to the rights to information and data protection. Given the current state of scientific discovery, everything indicates that within a few years, the legal protection recently established in several countries for the rights to information data protection will be insufficient to effectively guarantee these rights in the face of new technologies. Here, I want to draw attention to the current process of specifying the rights to information data protection due to the growing development of artificial intelligence and biotechnology. In a few years, it will be necessary to expand and strengthen the protection of information and data and personal data in ways never before considered by various legal systems. To confirm this reality, it's necessary to understand three characteristics of technological development in recent years. First, computer networks are increasingly powerful and, from an economic standpoint, increasingly cost-effective. Second, knowledge about human biology is increasing, especially about previous unknown biological mechanisms such as brain function. And third, engineering has become possible on ever smaller scales with surprising advances in nanotechnology. This increasing development of these three areas will culminate within a few years in the connection of the human brain to computer networks. Nanotechnology will enable the collection, transmission, and storage of human brain information in a kind of cloud of virtual neurons. This will be the fusion, that's the point, of human intelligence with the artificial intelligence of computers, a phenomenon that will pose unprecedented challenges for the legal protection of personal information and data. So I think that the fusion of humans with artificial intelligence is no longer the stuff of science fiction and should now become a matter of concern for legal scholars and legislators. The current technological possibility of merging human intelligence with artificial intelligence has generated new demands for legal protection of the human brain, not only in its physical integrity, but especially in relation to the information and data it contains, thoughts, memories, for example, images, visions, everything is in the brain. These new demands have given rise to new rights to the protection of brain information. In this emerging technological context, the so-called neural rights, it's a new concept, neural rights are developing in processes of specifying not only the rights to physical integrity and privacy, but especially the rights to information and the protection of personal data. These well-known rights are currently undergoing constant change in the content, transforming into types of neural rights, or the rights to the protection of human brain information. The neural rights arise to expand and reinforce the protection of information and data on the human brain against the threats proposed in the new technologies that connect the human brain with computer networks. Neural rights are currently challenged by the need to guarantee legal protection from the different demands that arise in the implementation of neurotechnology, such as, first, safeguarding personal identity developed autonomously by one's own consciousness. Second, protecting the autonomy of will and the free development of personality through one's own thoughts and reasoning. Third, protecting the privacy of thoughts, images, visions, and memories. Fourth, ensuring broad and unrestricted access to information about brain data collected by neurotechnology. And fifth, ensuring protection of brain data from collection, transmission, storage, and that's the important, commercialization or any other legal transaction involving source data. These new demands for the protection of fundamental rights certainly require the state to take a more interventive and regulatory role, especially in private relations. Due to the widespread impact on private relationships, these new rights emerging from the current technological revolution impose protective duties on the state, as well as constantly requiring positive interventions for their effectiveness. In this context, it's necessary to reflect on the path that legal protection should take, taking into account the risks of insufficient protection on the one hand and excessive state intervention on the other. As some experts have warned, the so-called the next wave, proxima ola, a current phenomenon characterized by the development of artificial intelligence and biotechnology, is posing the difficult challenge to constitutional democracies of building legal orders that protect personal data and prevent them from becoming totalitarian and authoritarian regimes. Therefore, I believe that in the coming years, the theory of fundamental rights will face these difficult challenges of building the theoretical basis of these rights emerging from the current technological revolution, developing its theoretical phase of rights to protection by the state without creating the legal conditions of a totalitarian surveillance regime. Current mutations in the rights to information data protection will continue to demand new legal protections from states, but at the same time will bring demands from society for greater oversight and control of state activity in data processing. With this structure in full mutation, the new rights to information data protection emerging from the technological revolution take on these dual theoretical characteristics, constituting at the same time rights to positive and negative actions from the state, but both from the state and from private powers. The new challenges posed to the theory of fundamental rights are truly complex and difficult. So, as a final reflection, I would like to draw attention to the fundamental role of jurists, especially constitutionalists, in the theoretical treatment of these new emerging rights in the context of the technological revolution. the fusion of human intelligence with artificial intelligence is a completely new historical fact that poses challenges never before faced by legal scholars. So the question, how can we provide enhanced legal protection for human information and data in computer networks without creating legal regimes of totalitarian surveillance? How can we theoretically shape new neural rights so that they sufficiently protect brain information and data without creating mechanisms of disproportionate intervention in the physical integrity, autonomy, and privacy of individuals? I think these are important questions that currently deserve further investigation, study, and theoretical reflection. So with these final considerations, I hope this interest group on emerging rights can continue the studies and debates of these issues. Thank you very much and good afternoon.
Thank you very much.
Thank you, Maria, for inviting me to this panel. It's like an honor to be surrounded by real colleagues. And my position as one of the junior members of the panel and of the interest group, I decided to narrow the scope of my presentation and just focus on a particular specific emerging right, what I will justify as an emerging right. That is the right of internet access. As I deploy it, I work as a researcher on emerging rights. Is a threefold task. On the one hand, we trace back the genealogy of a particular right, when and how it has appeared in political and social debates, also like in document debates, like the international, national, and regional level. So like in legal abiding documents, but also in soft law documents. On the second hand, what we do is like we test the ground. We test the justifications for granting a particular demand the status of a human right. And in the third, finally, what we do is we explore the content, what are the concrete obligations, the right holders that derive from that right. So I divided my presentation into these three parts. First, I will speak about will give a little bit of context, and I will see how internet access as a human right has appeared in the language of human rights. And the second part of the presentation, what I will do, I will explain what are the content and the obligations that derive from that right. And finally, I will explore what is the normative justification and under this obligation. It's important to say that this task of these three stages, we shouldn't see it as three stages that come one after the other, because it will be banal to make or give a solid ground and speak about the content of a right, of a claim that have not been claimed by any social actor, or is not supported in any legal document. At the same time, it will be difficult that a right that has appeared in a particular document gain traction and evolve and become a legal right if it has a lack of normative support. So we have to think about it not in like 3 stages phase that one can one after the other, but in a kind of dialectical process or like interrelation between among the three. I spoke about how the presentation is divided, and then we come about what is the context of the development of the internet access as a human right. First, I think that there is like a common ground, like the development of the internet in the last 3 decades have deeply changed how contemporary societies are organized, and has become now like an essential tool, not only for access to information, but also for like many practical things. In the same way, like being excluded of the internet is, we can say that it's like how being excluded of society, because citizenship and everyday interactions are occur along the internet in a daily basis. And within this context, there has appeared what we call like digital rights, that these rights are, on the one hand, an extension of traditional rights in the digital environment. On the other hand, are new specific rights, and this internet access or other ones like digital identity and data protection and this kind of rights. Internet access appear one of the milestones for the recognition. For its recognition was like the Millennium Development Goals set in September of the 2000s. We see there in paragraph 20 that it was recognized that the source of the benefit of the new technologies should be available to everyone. From that moment, in several United Nations resolutions, especially within the framework of the World Summit for the Information Society, we have seen that internet access appear as a human right that should be respected and guaranteed and ensured by all the states. And in 2011, the Special Rapporteur on Freedom of Expression of the UN recognized in paragraph 2 in like the report of the year that internet access should be recognized as a human right and have like two dimensions. On the one hand, is should be is like the access to online content without restriction, without interference, undue restrictions by the state. On the other hand, we see that the internet access states should provide like the infrastructure and the technology necessary to make that access materially possible. In subsequent reports, it has continued to be recognized by the UN relator. Also, on the European context, we have two frameworks. On the one hand, the Council of Europe, in the several resolutions of the Council of Europe Parliament also appear internet access as a right, and even in the European Court of Human Rights, we have several judgments in which, in connection with Article 10 of the European Convention on Human Rights, the court recognized that internet access should be ensured, respect, and guaranteed by the different states that has signed the convention. On the other hand, in Europe, we have like the European Union. The European Union, just as we all know, one of the competencies of the areas that regulates is like the European market. And in this context, when we regulate the telecommunication market, recognize that access to the internet should be provided to all the citizens in a non-discriminatory way, in affordable, high quality, broadband, and so on and so forth. Also have like the European Declaration of Digital Rights and Principles for the Digital Decade, that is a soft law document where we can see like the guiding principles for internet access in the European Union and the EU context. I'm sorry because I haven't done like the comparative law approach where we could see what happened like in the American system of human rights and the African system of human rights. I don't remember now by heart, but I'm sure that in the special rapporteur reports, I see that I remember that there are several ones on internet rights, thematic reports done by the special rapporteur on freedom of expression. So I'm sure that in the Inter-American Court of system, also like internet access has appeared as a right in several documents. I don't recall that any of the judgments of the Inter-American Court of Human Rights so far have recognized it. And in the national level, I will focus like in the Spanish framework. The first time the internet, the right to access appeared was in the data protection law in 2018. where it is recognized that everyone has the right to access internet, regardless their personal, social, economic, or geographical circumstances. Also, it appeared in the General Telecommunications Law 2022, where we have like the main contribution of that law is that it gives a detailed content on the rights. In the Annex 3, we can see all the obligations that shall be met by the state. And lastly, we have like the digital rights charters that where we have like the guiding principles for the development of new rights in the digital environment, and also like for the adjusting the traditional rights to this new digital context. In Spain, we are divided in several regional autonomous communities. We can see that in several autonomous communities constitutions, regional constitutions, internet access appear either as a right in two of them, Andalucía and Comunidad Valenciana, and framed as a guiding principle or directive principle in 6 or 7. And then we'll move on to what kind of obligations entail recognizing internet access as a right. And I follow the work of Tamara Alvarez when I say that it rests on 3 main pillars. On the one hand, it's like the obligation that the state should meet to develop infrastructure and technology to make effective the access to the internet for like the population in the whole country, no matter gender, no matter social groups, no matter also like geographical distribution of the population. On the second hand, there is like a strategies on digital education, digital literacy that can also fall under the scope of these rights. And lastly, we have like the rights of not the relation to non-interference or undue restrictions on the internet access. That it could be like an important part of the right, the kind of negative obligations, like for example, like the prohibition of taking down website without proper legitimate and necessity and proportionality, or the blockage of the digital platforms or like internet as a whole, as we can have seen in several countries. For example, in the European context, although overseas, we have in the last year the question of Nueva Caledonia, where France blocked TikTok when demonstrations for the autonomy and the independence of the region were like on the scope. Regarding positive obligations of digital literacy and also the development of the infrastructure appear here, but also when we speak about internet access, we don't only have to think on states, but also on digital platforms and telecommunication companies, that it will be a violation of the right that they block the access to citizens without the due motivation. This will be like positive obligation and the obligation to protect. These are some of the guiding principles that will guide the content of that right. And then the last part, I move to the normative justification of the right. We all know that human rights has evolved over time. In particular, like the content depends on the circumstances that people live in, and also the development of technology and the changes in society change what is the content of the different rights. For example, we cannot think of press freedom or broadcasting rights if the technology were not developed, or we cannot think on the right to form trade union in a society that is not capitalist. In this context, there is no doubt that the internet has been one of the major disruptions that we have had in the last decades, and it has changed our life in all the states. But I think that it's difficult to justify that internet as such has an intrinsic value in connection to human dignity, freedom, equality, or like that it needs like a social necessity or like a social need that is so essential for humans that as such give it like an intrinsic value. I think when we speak about internet access, we are more in the realm of instrumental rights. I mean, a right that is not has value on its own, but is extremely beneficial for making use of already established human rights. For like a medium for another right. It will be like some kind of instrumental right. But yet, when we speak about the usefulness of one right for another, I think like two questions at least come to my mind. One of them is obvious, is like how can usefulness and instrumental value alone justify rights? And the second one will be how can we test if something with instrumental value has the threshold that justify making it a right? Thinking about that questions, I think like following, reading like some of the literature, I think like first, one right is sufficient. Usefulness and instrumental value is sufficient to justify one right in two cases. One is when it's essential for the development and the exercise of the other right. And on the second hand, it is not essential, it should be like practically indispensable, not for any right, one right in particular, but highly useful for a range of other rights. It will mean like it's not particularly necessary for one right, but it has like a systematic indispensability. It's useful for several, for the recognition, for the exercise of several rights. I think when we have meet one of two criteria, it will be justified that an instrumental right is recognized in the language of human rights. And I'm just like in 5 minutes, 2 minutes, I like 2 minutes, I'm almost like at the end of the presentation. I think when we are like in the second case, it's more difficult and more complex because like the systemic indispensability is like a weaker kind of argument because supporting the relationship between the right, the instrument, and the end, this has like practical alternatives, so it's more difficult to justify that should be like recognized, and also because we should weigh like the different alternatives that we have. In any case, I think, and with this it comes to an end, I think in the case of internet access, is sufficiently justified that at least is essential for the exercise of the rights related to political participation, freedom of expression, freedom of information. Also the right to association and peaceful assembly, that where is not only an instrument for organizing a demonstration, for example, but it could be internet, the medium where like a demonstration or an organization take place. We could gather online and not in the offline world. And also to the right for political participation, all these three rights, we should not be surprised, at least like the US Supreme Court in 2017 recognized that we live now under the modern public square is the digital public sphere. So like if we can, although we can think of exercising these rights in the offline world, having it online is almost like indispensable nowadays. But we also have like other rights, like the right to education, cultural participation, or the right to work, where internet facilitates the way that we enjoy and we take advantage of the right. I stop here because the chair is like really and thank you very much.
Thank you very much.
Yes, I represent the community because you have used all my means that was the flexibility wasn't the case that she has a right. Thank you very much. And we are suffered an accident and sustaining injuries. Oh, so this is really extra responsibility, Magdalena, an exercise of extra responsibility. Thank you very much. Thank you very much. The machine is with you.
Well, good afternoon. I'm sorry, I had an accident this morning. And in fact, I'm here because of you, because you said. And I think it has been a good order in which you spoke, because I would say that my presentation started from a criticism against the emerging rights. Then, why? Because my point is analytical, but indeed your last work went in this way, then that helps a lot. The content of my presentation will be this one, and in fact, I will talk about 5 points. What are we talking about? What is this? Is this new? Are they new rights or are equivalent to another category that we already know, that is the non-enumerated rights? Let's take some definitions, examples, and of course, a choice. And the other point is, are they historical foundation of human or fundamental rights as any right? Well, the first point, what are we talking about? Why Bob Marley? Because my school of law is very low, but I'm constitutionalist. Then I have both spirits, very lawyer and very Bob Marley in a way, because yes, constitutionalist, we always want to, another word of love and peace and universal internet. Then I try to be in the middle, but trying to work in the way that what we feel became something real, something useful for the people. Well, then let's start with the foundation. I've seen that you look very young professor, but already professor. I don't know if this is very simple, but well, the emergent rights have a very easy foundation in the constitutions. I don't know how expand is this clause at the constitutions, but in Latin America, we have Ecuador, Bolivia, Colombia, or as examples, this is not all the list. We have this clause, open clause, to recognize that the rights on the constitution and the rights on the human rights treaties that the state is obliged do not mean that though this list is closed, because justices and the legislator can recognize more rights that the people need for their dignity. And this is constitutionalist in Latin America. We are becoming very conventional constitutionalist. And this clause is also in American Convention. Restriction regarding precluding other rights or guarantees that are inherent in the human personality or derived from representative democracy as form or government. And there is another one, perhaps if you recognize very well this topic, the 9th Amendment of the United States, that in the United States is not very, very fancy, but for us it is. The enumeration in the Constitution of certain rights shall not be constructed, denied, and disparaged, other retained by the people. Then we have a good foundation. But At this point, I start to say, well, yes, we have a foundation. We don't have yet definition, but we have a list, not a closed list, because this is emerging every day. I'm exaggerating, but it is emerging every day. Then on the Universal Declaration of Emerging Human Rights, then the right to peace, with human dignity, as Professor Juan spoke, the right to environment, and the right to democracy in many ways: egalitarian, plural, parity, participative, solidarity, and guarantee. But there are other lists from the studies, for instance: the right to land, the right to development, the right to tobacco control. I found some article about it. And in artificial intelligence, I wrote, oh, let's tell me what are the most important emerging rights on the table. Then I found this list. Healthy, two about climate, healthy and sustainable environment, climate justice and environmental protection, equality and non-discrimination, digital rights, as you spoke, protection against abuse in conflicts, rights of migrants, economic and social equality rights, as Professor Cruz says. Oh. And this one, which is very important for us in Colombia, the expanded recognition of collective and non-human rights, in which we find something very particular. It was the rights of indigenous, but also the right to the city and the right attributed to nature, as well as the rivers, and to future generations. With this, all this long and not finished list of emerging rights, come the second idea. Is this really new? Or we are talking about the first point, the innominated or non-enumerated rights? But in our doctrine, I found something very interesting that could be not true, but I think this is a good idea. There is a difference. The difference is this one. Emerging human rights come from the activism of the people. Principles or prerogatives that today appear as demands from globalized civil society have become ethical obligations towards states and international community. But the non-enumerated rights, which we know very well since long time ago by the constitutional courts, are something recognized by the courts, by the justice. Those fundamental rights recognized, created, interfered through jurisprudence by means interpretative criteria and considering the existence of non-enumerative clauses. This comes from one of the first rulings of the Constitutional Court in 1992. This is an important difference? I would say yes. This is my conclusion. Well, this is another thing, and it comes also from the declaration, the presentation of the Declaration of Universal Declaration of Emerging Human Rights. It's a programmatic instrument of international civil society aimed at the state actors and other institutions for crystallization of human rights in the new millennium. So, then could be something different? Yes. Then, at this point, I'd start to work on the structure, what you did in the right to internet, but I tried to think about the structure of the emerging right. Then, you use another word, a better one, entitled? No, el sujeto. Holder, the right holder. Who is the right holder? Well, this is open. All depends on the right. You spoke about neural rights, human persons, legal person, digital rights also, social groups, for instance, the right to the city, nature is itself, the right to climate change, non-human rights, I don't know what kind of rights, but they are talking about. Who has to do what? Who is obligated to do something? Because I think this is the most important thing I will learn that since the beginning of the theory of the guarantees. If you don't have a guarantee or someone obliged to do that, you don't have a right. Then the parties, you spoke about the state, but I'm pretty sure, of course, the state, but the state is not sufficient at all. In this period, with these new complex rights, we need especially privates, and we need states, the international community, because many of the problems have to be solved by the international community. And for that reason, we spoke of the first constitutional foundation, but afterwards, the foundation and the legal sources of the emerging rights must come from local, national, regional, and international law. Well, concerning the content, right to what? Then I think we have to take the same contents, the classical contents, liberties, equalities, provision, right to do something, guarantees, duties. We can take all this structure and try to find what kind of liberties or equalities or guarantees we need to understand what does the emerging right mean. But of course, if we identified some content, we have to identify who has to do what to satisfy this content. But the point, and I think I agree with you, and I think that we will take this as an approach for many emerging rights, is that the difference between put together freedom of expression, the right to participation, the right to honor, linked it with the right to internet, is that all these contents that take rights, classical rights, non-enumerated rights, collective rights, individual rights, all this mixture should be fulfillment as a whole to satisfy the big emerging right. Otherwise, I give the example with the tortilla española. Tortilla española is not potato and eggs. No. It's a miracle between both ingredients. When Colombian people make tortilla española, the flavor is patata, potato, and egg. No, but from Spain is something different. It's the paradox. I will say that an emerging right is like a tortilla española, because you take some rights from some classical rights. You gave an example. You gave an example very classical. The list were classical rights, but those rights need to be together to fulfillment at the same time to have the right satisfied. Four. And this is something that I think is very interesting, because another point for my dogmatica, my school of law of lawyers, 2 lawyers, was something like that. But why are we talking about emerging rights if any right have emerged? All of them are emerging rights. All of them, because the history, and you are very strong in history of rights, the school of Carlos III are very, all of them come from necessities, aspirations, and demands. What is new now? I think the novelty is what I proposed at the beginning. Now we take the information very fast. Then the society, the movements, the lawyers, the organization start to understand that there is something that is happening somewhere. And this association tried to push this movement, try to do something more than to wait the time that takes regularly a right to be strong. A matter of litigation. And I can give you one example. I'm working right now, I'm professor from the Externado de Colombia, but I'm working right now at the Ombudsman person office in Colombia. And they started a very nice policy about emerging rights. And they invented one. Well, I don't know if this is new, but it's something very interesting and very new. And they start to follow and try to write, they are trying to write a guide to help the people to use emerging rights. Juridification, starting to do what I did, setting the agenda, how it works on the politicians are talking about, the justices are talking about, the academia, and positioning. Positioning means that the people already knows what are we talking about. And the particularity of this work is very nice because I give you one example. In Colombia, everybody knows, or many people knows that we are talking about the right to a river. And that starts to be very famous all around the world. In a group, we have any week, we have a new decision about rights to a river. This right is very well positioned, but it's not in the agenda and not really has juridification. Then this is the reason why it's so important to work in the way that to understand very well what can we do with this aspiration, with this necessity, depending on the moment we are, because of course, the example you did, it was something more that is part. And the last point, I think that this is, in any case, I think the emerging rights, another condition, perhaps this is more risky because you said something else, is that these are also rights mostly of judges. The beginning of these rights are mostly from judges. Judges who develop the Constitution or the international law treaties before legislators or general assemblies. Why? Because this is something that, in fact, the evolution of society and the evolution of necessities and aspiration need. And fast answers, and the very fast answers come from justice. This is not necessarily means that this is the better solution, but is the solution we have in this transformative democracy right now. Thank you. Bye.
Thank you very much indeed. You have done this, I think. Thank you. And it has been an amazing presentation. I think that it will be the origin for a debate that is open now. So between the people in the table or with the people in the public or the people who is following us in the broadcasting, you have the word. Okay, please let us know who are you.
Sure. My name is John Green, and I'm a practitioner and a PhD student at the University of London. My apologies, I came in a bit late for the introduction, but I did have a question for the professor who spoke about the right to memories and the right to, and so I want to know, do you think that most constitutional provisions of privacy are sufficient for things like memories, thoughts, or how can those provisions be expanded to include what you mentioned as things to look for in the future?
Thank you for your question. I think we have a big problem of specifying the well-known rights to information and data protection. We have difficult challenges, both legislation and jurists. In my presentation, I have spoke about of some duties of the states to safeguard neurotechnologies. I think it will respond your question. The first duty is to safeguarding personal identity developed autonomous by one's own conscience. So memories, visions, images, the state have difficult challenge to regulate these rights right now. Second, for example, protection protecting the autonomy of the will, including own thoughts and reason. Third, protecting the privacy of thoughts, ensuring broad and unrestricted access to information about brain data collected in neurotype. And fourth, the commercialization of this data. It's a difficult challenge. We have a big problem. If you have saw the last series of Black Mirror, have you seen the Black Mirror in Netflix? Yeah, the last episodes demonstrates the difficulties of the emergence of neurotechnologies and the problems we have in society about protecting well the rights of the brain, the integrity of the brain, and the data inside the brain, information, memories, visions. So we have some old constitutions with well-known rights to information and data protection, that these rights is in continuing processes of specifying. And so I think the neural rights are the result of the processes of specifying these well-known rights of information and data protection. So I think we have some issues to work in the academy as constitutionalists, as jurists in our university, and especially in our group of emerging rights. So thank you for the question.
Okay, thank you.
Thank you very much for an amazing panel. I was thinking about also the consequences of creating these new rights, in the sense of what other rights they face or they challenge. For example, taking into consideration the content that you mentioned about the possible major rights to access to internet, the construction or the infrastructure that they will need. What are the environmental implications of that infrastructure, for example? What are the democracy implications that I think we are seeing right now of the non-interference principle in the right to access to internet, for example? So in that regard, my worry is to what point this new right could be like tools to face the protection of other well-established rights.
Thank you very much. I think like this is a very interesting point. Because of course, if we like the status of a right, particular claim, you are like putting that claim on the equal ground with other ones. And then we have to wait and we have to balance between different rights and to see which one we pursue or which one is like more important in a particular context or the other. The question of internet access, that in my case, I try to follow how it has appeared, but I don't have like a strong normative interest on internet access to be recognized as a right. I think there is a question of pragmatism. Internet is like now involved in our daily life. To participate like different groups, we have to be involved in what is happening on the internet, and for voices to be heard, internet is needed. And when we guarantee internet access, we are somehow some of the obligations, especially positive obligations, are thought for like exclude and disadvantaged groups, because that are the ones that are like in the periphery, not in the centers of the capitals, the one that doesn't have enough money to pay, because there is a question if the internet should be affordable or should be free. for the ones that cannot pay, are the ones that cannot participate in these citizens of society. So society that in a pragmatic terms is using internet for everything. Of course, we could say like, okay, could we protect it and the content of the other rights? So one is particularly useful for freedom of expression, of to organize an assembly, we could go and try to guarantee internet access case by case, not having like a right for the whole. But I think like creating a right somehow take out these kind of obstacles and debates that some of the vulnerable groups cannot face in day to day, and also give us the opportunity to debate what is the content of internet access, what should be protected inside the right, what are the derivative rights of internet access, and how can be balanced with the other ones, because what is clear is like somehow is organizing our societies. So I think like there is a pragmatic argument to.
So let me add something. I will say that this topic has some leitmotifs. And one of these one is efficiency and efficacy. Because we are mentioning about this new, which is new. There are some things new that we don't have an answer from the classic rights, I would say. But there are others that are very always, no? Migration, equality. What is new? Efficacy. They might think the idea to work together with the state and the private actors and the state administration and the state legislator and the local state all together is the idea to make efficacy the rights, all the rights, perhaps the rights most important to be in peace, the rights for people and access to knowledge.
I think it demonstrates that Gregorio Pesquisa was right about the process of specification of human rights based on the theory of Norberto Bobbio, the process of specification of the classical rights, of the well-known rights postulated in the Constitution. I think we are talking about the continual process of specification of well-known rights in our Constitution. Right? Yes, thank you.
Thank you. Well, last chance. We have something. Yes, of course.
Thank you for the interesting panel. I think with I mean, the word rights itself is very loaded because I don't think we necessarily have a hierarchy of rights, but I would say that rights are definitely not equal to one another. Like, and just from a description of the right to the internet, for example, to maybe the most tangible one we have here, you already identified multiple rights that this vertically intersects with. It's an intersecting right. And I would compare it to maybe the right to the water and how like Saska justified that through two different rights. And almost overnight, like it was almost like instant custom where all of a sudden everyone's state report was like, oh yeah, we have water, we provide water. And I think maybe I misinterpreted when you said like, oh, like it's a right and something like it comes with all of these different things. Like it's a hard threshold to reach. I wouldn't say that's necessarily the case. It's just, I think it can be okay to be a right that's also supplemental to horizontally to many other rights. Like I know it's a bit Frankenstein together, but sometimes if we don't do that, then we risk fragmentation of our idea of what the internet is or what the right to a river could be, because it could be, do I have to go through two different legal processes to get that part of my internet, you know? And this is true for any, because I think now when we're talking about contemporary emergence, it's about a lot of these rights can be messy and complicated and things like this. And that's just my general comment, is also thinking about maybe, also thinking about reconceptualization on how rights intersect with each other, I suppose.
Okay.
Okay. Well, we are done. So thank you very much indeed for your intervention. Thank you, Magdalena, for coming. And it has been a pleasure to hold the presentation. Thank you to the public. Thank you to the public who is following the retransmission, the session. And we are now pleased. I would say that perhaps we have enjoyed an excellent overview of trends in the development of human rights theory and regulation. We will endeavor to ensure continuity in our activities throughout this year until the face-to-face meetings next year. And please register on the website so we can start building a community of scholars working in this field. So thank you very much indeed, and to the next.